My name is Patricia Fonte, and I am a cisgender, straight woman in a heteronormative relationship. So who do I think I am, coming to you today to talk to you about estate planning for the LGBTQIA plus community? Well, what I hope I am is a really good ally. I am obsessed with white papers and talking to members of the community and providing education and listening and meeting with financial advisors, insurance brokers, business attorneys who all work with the community and talk to me about the specific issues that their clients are facing. Today, I'm going to talk about estate planning for the LGBTQIA plus community. It's not just about money. It's about identity, dignity, chosen family, housing, affirming care, the safety of children, and legal authority during a crisis. And honestly, a lot of the legal system still defaults to assumptions about what a family looks like. And these assumptions can be really dangerous during incapacity, hospitalization, long-term care, or even after a death. Let me give you a couple of examples. A woman is rushed to the hospital and her wife arrives on the scene. The wife thinks, well, I'll just make all of the medical decisions. But here's the problem. The patient's mother has arrived. Now the hospital is nervous. Do they listen to the mother or do they listen to the wife? Now, here in California, the doctor in charge can make decisions. The doctor can decide, well, it's going to be the spouse. But we don't know this doctor. We don't know if this doctor is bigoted. We don't know if this doctor is just a fraidy cat and refuses to make the decision. So who gets information? Who gets authority? Who gets to make decisions? You don't know. There's no rule. Here's another scary story. Two dads are raising children together. One dad is on their birth certificate. The other dad has no legal relationship to the children, and something terrible happens. So now suddenly a court, not the family, gets to make decisions about who has legal authority over these minor children. It's another example. A single LGBTQIA plus adult dies, and their closest friends, their closest relationships are with their friends, their former partners, their chosen family. California law does not recognize chosen family. Without estate planning, the wrong people might inherit, the wrong people may make medical decisions, and the wrong people may control funeral arrangements. I've seen situations like these happen. Someone in my own circle died at home, and their closest friends, the people who loved them the most, were thrown out of the room by the medical examiner. They had absolutely no authority to make determinations as to what should happen to their friend's remains. And this friend, their blood relatives, wanted nothing to do with them. These aren't hypothetical situations. These things happen. So which documents should be included in an estate plan? All the typical documents. The revocable trust, a will, advanced healthcare directives and HIPAA waivers, powers of attorney, guardianship for minor children, and very careful attention paid to the title on assets and the beneficiary designation on assets. But great planning for the LGBTQIA plus community goes well beyond the standard forms. The devil is in the detail. And most clients also want provisions addressing gender affirming care, mental health treatment, affirming caregivers, chosen family authority, housing protection, guardianship concerns, and the exclusion of hostile individuals. For transgender and nonbinary individuals, the documents may also address chosen names, pronouns, memorial wishes, and identity protections after death. So can your spouse or partner automatically make medical decisions for you here in California? Most people assume yes, but it's not true. California law is much more complicated. Without an advanced healthcare directive, no statute automatically puts someone in charge. Not your spouse, your adult child, not your parent. Some states do have those rules. Here in California, we don't. Instead, we have something that's very wiggly, where the attending physician can make that decision in the absence of an advanced healthcare directive. So generally, the hierarchy would be a spouse, then an adult child, then parents, then siblings, then grandchildren, maybe even close friends. But this is not the same as having a carefully drafted estate plan. The healthcare provider is deciding who is appropriate. And the reality is you don't know this doctor or nurse or administrator or social worker. You don't know if they're affirming, biased, uncomfortable, or just openly hostile. For transgender individuals especially, this can involve dead naming, interference with affirming care, and complete disrespect for identity, really during moments where you're the most vulnerable. And that's why many LGBTQIA plus estate plans include affirming care provisions, mental health provisions, gender affirming care language, and instructions to seek LGBTQIA competent caregivers and facilities. So how can LGBTQIA people legally protect their chosen family. California law just is not helpful. What happens if my unmarried LGBTQIA plus partner dies without a will or a trust in California? Oh, California law may not protect your relationship. We don't have common law marriage here in California. Many members of the community built their lives before marriage equality came into existence, and they still haven't gotten married, whether it's for financial or legal reasons. But without proper planning, that surviving partner might inherit nothing. Imagine that you're living in your partner's home when your partner dies. You're not going to inherit that home absent an estate plan. Their blood relatives are going to inherit it. And now your housing is dependent on the kindness of people who might be strangers to you. Many people assume, we've been together forever. Everybody knows that we're family. I will be taken care of. Funny things happen around death and money. And California law may not see it the way that you see it. Do LGBTQIA parents need guardianship documents? Yes, like all parents of minor children. Absolutely. The lazy shortcut is to name a couple of guardians in a will. This provides a judge with absolutely no information as to what is in the best interest of the children. Here at Fonte Law, we have a long-form guardianship nomination form. We list interim guardians in the event of a short-term incapacity or just until the chosen guardians can arrive on the scene from wherever it is that they might be from. We're also going to list your chosen guardians and then some backup guardians because, you get to choose who's in charge of you, your healthcare, power of attorney. You get to choose who's in charge of distributing your assets under your will or your trust. But a judge decides on the guardians of your children. You get to nominate, and it is absolutely mission critical that you put your best foot forward. We don't want the court to simply decide that the nearest blood relative that you would never choose is best suited. We don't want children removed from affirming communities, and we don't want to be in a situation where hostile relatives try to take control. These can become really complicated issues where there has been assisted reproductive technologies have been used, there are blended families, non-biological parents, or complicated parentage histories. A thoughtful guardianship nomination form may specifically state who the parents trust, who should not be considered, and why, the importance of affirming communities, and the family's values regarding emotional safety and identity. But what about single people? Do single adults need estate planning? Yes, often urgently. Many LGBTQIA adults are single, child-free, and they're either estranged from relatives or they're deeply connected to their families and will likely be sought to serve as caregivers, either for their biological families or for their chosen family. Without planning, chosen family would have no authority, and nobody would have the authority to help during incapacity. For those who anticipate serving as caregivers, the people who are counting on you, they owe you an estate plan. They owe you a healthcare directive and a power of attorney. They owe you a will or a trust or a beneficiary designation on a bank account that acknowledges your financial sacrifice. Can estate planning documents protect gender-affirming care? Yes. For trans and non-binary individuals, estate planning can help protect identity, privacy, dignity, and affirming medical care. The documents can address hormone treatments, chosen names, pronouns, mental health care, trusted decision makers, and also funeral instructions. This isn't just medical treatment. This is about dignity. Can estate planning documents require affirming caregivers? Yes, they can. Many older members of the LGBTQIA community rightly fear discrimination, dead naming, isolation, and being forced to recloset. A well-drafted plan can give the right people the authority to find the right type of care that doesn't lead to these really negative outcomes. So what does California law do if you don't take care of this? It applies default rules. And default rules are problematic. The default rules are if you lose capacity, conservatorship. And hopefully it's someone who loves you who approaches the court and says, Your Honor, I really need the authority to care for and act for this person, and not someone who simply wants to control you or get their hands on your assets. The default rules do not address your identity, your relationships, your chosen family, your children, or your values. And the law doesn't know who you trust or who makes you feel safe or who you never wanted involved. I recently published a new blog on estate planning issues for the LGBTQIA plus community. It is one of 3 blogs on this topic on my website, www.defontelaw.com. I want to wish everybody happy Pride. And for those of you who are working with the LGBTQIA plus community, if you're a lawyer, a therapist, a CPA, financial advisor, realtor, or a health provider, I really encourage you to educate yourself about these issues. My name is Patricia DeFonte. I'm the founder of DeFonte Law, where we practice estate planning with heart. And that means that we do not work with bigots. I would be shocked if a bigot was watching this deeply into a video. But if you are, and you're just raging at me, you just block me, just pretend we never saw each other. Thank you so much for staying to the end of the video. Please like and subscribe.